All right, let's get into this Janus stuff. We're going to be talking to a professor tomorrow. Oral arguments are happening today. I just want to tee this up for you. Janus, we spent a lot of time talking about Friedrichs. I guess now this is 2 years ago. And it was probably about 2 years to the day that, was it 1 year? When did Antonin Scalia die? Did he die last year?
No,
It was 2 years ago. It was during the election.
It was about like March or April
of
2016.
2016. Okay. So 2 years ago.
I'll check our celebration text.
It wasn't right. It wasn't quite on the eve, but it was pretty close to the eve of the deciding of the Friedrich case. The Friedrich case was a case brought by a California teacher who was arguing against agency fees. So back, I don't know, in the mid-'70s, there was a case, Detroit versus Abood, or maybe it was Abood versus Detroit. I can't remember. And in this case, the Supreme Court found that you could split up the dues that people who are in a closed shop are forced to pay to unions. Because here's the deal. An employer wants to deal with one bargaining entity. And particularly when you're talking about a municipality or a county or a state, they don't want to deal with negotiating with tens of thousands of employees. They want to negotiate with one entity. So it makes sense from the perspective of one of these entities to say, okay, we're going to deal exclusively with the union. Anybody who works here, the union's going to represent them. The Supreme Court found that you could not be forced to pay unions for their political advocacy. But in this Abood case in the 70s, they found that, however, there is a certain percentage of your dues that goes towards paying for people who are representing you in the negotiations. The lawyers, all that's involved, and that costs money and infrastructure. And then the ongoing dispute mechanisms and whatnot. So that was settled in the 70s. And of course, conservative justices really, the originalism, all of this, they are agenda driven. And when this case came up back in 2016, 2015, 2016, it was quite clear that the conservative justices, 5-4, were going to strike this down. Then, and I don't know if you believe in God or just fate or karma or humanity or just goodness.
Or only so long you could abuse your body with those meals.
All of those things or one of those things, or just good fortune, manifested itself.
Bad things happening to bad people sometimes.
Right. And Antonin Scalia wrapped up his very, very corrosive life. And and
not like Blink. You gotta do it. That's right.
So he passed away. The Friedrich case basically was then deadlocked 4-4, and the lower court ruling, which ruled that agency fees, that's what they call it when you have to pay for your agent, essentially, were constitutional. Then you've got this Janus case, and it is essentially the same case. It is a guy from Illinois who is who filed a lawsuit. He was a state worker named Mark Janus. He argued that he has a First Amendment right to avoid paying anything to a union that bargains on his behalf, that it's an infringement of his free speech because essentially, and this is going to be important in the conversation we have tomorrow in terms of the implications legally, that even the negotiations itself infringe upon his free speech, that they are that those negotiations are speech, that counteract to his speech. Well, we're gonna table this because we're gonna talk about it tomorrow, that part of it. But what it's going to do, because it's almost a guarantee that the Supreme Court is going to find in favor of this guy Janus. It's going to make essentially every state in the union, and when it comes to public sector unions, a so-called right to work for less state. And therefore, you're going to have municipal workers who are going to say, like, I don't have to pay any union dues, but they're still going to negotiate on my behalf. Yeah, I'll do that. Now, a lot of people will appreciate, like, oh, no, it's important because if the union goes away, then I'm going to lose a lot of money. But look, let's face it. Not everybody thinks in that collective way. I mean, if Michael saw some means in which to save a couple of bucks and dish it off on the people here, I mean, come on. Even Michael, we know that would go down.
Right.
Right?
And well, I mean, I'm the bad example to use because I'm actually looking for ways to do that.
Well, that's why you're a good example.
No, but I'm saying,
you say
like
if
somebody
just showed up.
who's actually just going to take it versus
right.
somebody who's actively seeking.
Right. That's true. Michael leans into that a little more.
I always
Michael would bring the case.
Right.
In this instance.
I would be the guy who
Janus.
violates my speech. God damn it! How is this looking Michael wise?
We need more pizza for debate night.
Actually, we do.
Wait, why are you wrapping that up and bringing that home? I didn't order it last time. I left a lot of money.
Cheap corporatist.
So, all right. But tomorrow, today are oral arguments. The real interesting questions here are going to be, how will unions respond to this? How will conservative justices craft their findings in such a way to prevent potential unintended consequences that may come from this case? So I'm just giving a little hint as to what we're going to talk about tomorrow. But contemplate this. There are a lot of restrictions on collective bargaining, both on a federal level and on a state level. You look at what's happened in Wisconsin in 2011. You look at things like, even like Taft-Hartley, things like wildcat strikes. If it is the case that your First Amendment rights can be violated by collective bargaining, it elevates collective bargaining to speech. And if collective bargaining is elevated to speech, that has a whole raft of implications about a state or a federal government being able to limit collective bargaining in any way. So these are the questions we're going to be asking a labor law professor tomorrow. So make sure you tune in then. But I know you will.